This is Bloomberg Law with June Grasso from Bloomberg Radio.
The legal battle over President Donald Trump's executive order to end birthright citizenship is far from over, despite the administration's major victory on Friday when the Supreme Court limited an individual judge's authority to issue nationwide injunctions. Within hours after the ruling, lawyers representing the pregnant undocumented women challenging the executive order filed amended complaints in Maryland and New Hampshire, seeking class action relief in response to the Supreme Court's guidance in the opinion. Here are immigration lawyer George Escobar and Georgetown law professor Rupa Bhattacharya.
We are very confident that we think we can get relief from the district court and that class relief will hold up on appeal all the way up to the Supreme Court because this order is unconstitutional and because it is unconstitutional as to absolutely everyone that it would be applied to.
We very much look forward to the day as we continue to litigate this case when every court, including the Supreme Court, agrees that the president cannot, by the stroke of a pen, take away the constitutional right of birthright citizenship.
Trump's executive order will remain blocked for 30 days from the time of the Supreme Court's opinion, giving lower courts and the parties time to sort out the next steps. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, there were hearings before federal judges in Maryland and New Hampshire today over requests for class action relief. Tell us about the Supreme Court decision on Friday that led to this.
So what the Supreme Court did was they ruled that from now on, not just in immigration, but in other contexts, you couldn't get one district judge in a case where there's just a couple of plaintiffs that filed a lawsuit to issue a nationwide injunction that said, not just for these two plaintiffs, but for everyone in the country, a particular executive order or a particular regulation is banned from going into effect. That's what was happening previous to this decision, is there would be an executive order issued or a regulation issued, and people would go into court, and sometimes they'd go into court in various districts. They'd go in one district here, one district there, one district there, with the idea being that just if they could find one judge to issue a nationwide injunction, then they could stop it for everybody in the nation. And there were a lot of these nationwide injunctions being issued. The Supreme Court ruled in a 6-3 decision that violates the Judiciary Act and that's not what the courts have authority to do. They only have the authority to issue injunctive relief in a way that makes the people in the case itself whole, but not anybody who's not in the case itself. And so what they said is what you can do is try to get a class certified pursuant to Rule 23 of the Federal Rules of Civil Procedure. You can get a class certified. But what's interesting about the class certification is if you don't get it for a nationwide class certification, then it will only apply to the specific circuit or state, whatever it may be, that's the topic of the class certification. But if you do get a nationwide injunction, then what happens is then you can't bring the case in several courts. Once the first court issues a nationwide class certification, that's the class for the entire nation. There can't be competing nationwide certified classes. There can only be one. And then that's the decision. So if they win, okay, then fine, the executive order is invalidated. And that one is likely to get to the Supreme Court. But if they lose, then maybe that case will never go to the Supreme Court because then everybody lost. And sure, you'll go to the Court of Appeals. They'll get a chance to make the decision. But the Supreme Court may decide we don't want to take that case. And so you'll never get the nationwide decision that you might have gotten otherwise under the previous way things were being done.
I mean, also, it's not so easy to get a class certified, is it?
No, there's several problems. One, timing. It takes a lot of time to get a class certified. You have to file a motion. You have to show that the lawyers in the case are qualified class action lawyers. You have to show that there's a numerosity, meaning there's a lot of people who fit in this group. You have to show that the group is common, that there's not individual facts. Then, at least in the immigration world, in some of these cases, you can't even do a class action because the courts have issued decisions saying, no, these cases are fundamentally person-by-person cases. So, like, for instance, in indefinite detention cases or detention cases in general, they say the individual has to challenge their own detention. This can't be done as a class. And so in those cases, then you could even certify a class. You still couldn't do it because they're not letting you do it for that particular issue. But in other cases, the issue is going to be the timing, the cost, the expense, and then does this apply to just a specific group of people, or does it apply to the whole nation? So all of that becomes now very challenging to determine.
So since plaintiffs in both Maryland and New Hampshire are seeking class action status, are the plaintiffs in a contest of sorts?
Yeah, they're in a race to the courthouse now, and both are trying to get the individual judges to issue a class certification. Now, the one benefit that they have that people won't have moving forward is they already know that these particular judges are inclined to say that the Birthright Citizenship executive order is illegal. So from their perspective, asking for a nationwide class certification is no risk. But moving forward, the advocacy groups, whether they're conservative or liberal, they're going to have to coordinate and say, are you doing something too risky by asking for a nationwide class action? Because we don't know how this judge is going to rule. And so that's a very interesting issue that's going to come up moving forward. Here in the Birthright Citizenship, it's not really an issue because the judges have already issued nationwide injunctions that are instead going to be disbanded now as a matter of the Supreme Court. But at least you know they're inclined to do it. So asking for a nationwide class certification here is less risky.
Is the alternative plaintiffs going to judges in each of the 11 circuits and trying to get an injunction that applies to that circuit only?
Correct. And the problem is you would need probably a circuit split or something to attract the Supreme Court to actually take the case in that situation. And so that's where this becomes a problem, is if you had just one circuit saying that it was unconstitutional, but the other circuit's not, or not saying anything, who knows if and when the Supreme Court would actually be interested in taking these cases. And that's something Justice Kavanaugh said in his concurrent opinion, is he said, hey, we've got to still decide these cases quickly because this lack of uniformity is going to be a major problem if we don't decide these cases. And so we'll see if the proof will be in the pudding if the Supreme Court does this.
And the Supreme Court gave the Trump administration 30 days to what? To say how it's going to do the birthright citizenship ban?
Right, exactly. They now have to figure out what they're going to do, what they're going to do in the courts. Are they going to move to dissolve these injunctions? What is their position going to be? And from my perspective, this, to me, say what you want about the decision itself on nationwide injunctions, because it seems to me where people stand has depended on where they sit. And so sometimes the Democrats haven't liked them. Sometimes the Republicans haven't liked them. That's a separate issue. But to me, where I'm really confused by this decision is why the court wouldn't have just said, look, we need to do briefing on this issue of birthright citizenship because we can't possibly have a situation where we are allowing a circuit split or some other problem with birthright citizenship where some people can get it and others cannot, depending on what state they are. They should have just decided that as part of this, and the fact that they didn't seems to me to be one of the bigger problems with this decision.
So now we're also waiting for the Supreme Court to take action on Trump's attempt to send 8 migrants who are currently being held in Djibouti to South Sudan.
Right. Well, the Supreme Court has said that third country deportations are now possible and that there doesn't need to be this extra hearing where you're allowed to go in and say, but don't send me to these other nations. That actually is a decision that's been issued now that was done without any guidance. The Supreme Court didn't say anything, but they lifted a stay on an order that a district judge in Massachusetts gave, where he was talking about all the process that needs to be given if you want to deport someone to a country that's not their home country. And so now that doesn't exist anymore. And so from that perspective, what happened was the district judge has now sort of, in a sense, said, well, because that order wasn't very clear and just the stay was lifted, I'm going to come back and still say, no, there is a process you need to give. And so I'm not going to allow these people to be deported again. And so now it's going to have to come back up for the Supreme Court to actually use words and describe exactly what they meant as opposed to just lifting the stay. This judge is really forcing the Supreme Court to come back and actually shut him down if they think what he's doing is wrong by ordering, some process to be given to people who are going to be deported to a third country.
Well, it's good that someone's doing that because the Supreme Court, with all these orders that we've been talking about for months,
rules something, gives the bottom line, but gives no guidance to the lower courts.
Correct. This is going to be, I think, an inflection point for the Supreme Court. I mean, they can make decisions, obviously, of course. That's their duty, their right, their obligation. But can they make them in a way that actually provides some guidance and some certainty in these very, very important issues that are life basically altering for people, as opposed to just, lifting stays and not providing any guidance, any reason, anything. I think this is going to be a critical fundamental issue. Now, I know the problem is there's many, many, many executive orders issued and many, many lawsuits, and everybody's human, and there's 9 justices and 4 law clerks for justices. So there's only so many things that humanity can tackle at one given time. But having said all of that, it really doesn't help the situation when people have no guidance. If you get a decision that says, make sure people have a chance to file. Well, what does that mean? Those things sometimes cause more harm than good because nobody knows what any of those things mean or how to implement them. And everybody is litigating to get the best result possible. So no one is just going to accept those decisions and say that it meant something less than what the maximalist approach that each litigating side is going to take in a particular case.
Coming up, why Kilmar Abrego Garcia's attorneys asked a judge to keep him in jail. This is Bloomberg.
You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
The Fifth Circuit heard arguments today on the proper procedures the Trump administration must follow to deport alleged members of the Venezuelan street gang Tren de Aragua under the 1798 Alien Enemies Act. I've been talking to immigration attorney Leon Fresco. Leon, give us the background on this case.
So what happened was there were people in detention in Texas who were being charged under the Alien Enemies Act. And there was a lower court judge who said that the Alien Enemies Act, the procedure that was being used there, was an incorrect procedure, and the government needed to give people time, pursuant to the Supreme Court's decision saying that the government needed to give people time to use the habeas process properly so that they could say, hey, I'm not subject to this Alien Enemies Act either because I'm not the right person or because the statute doesn't apply to me or whatever it may be, the statute's unconstitutional, etc. And so those procedures, the government has been fighting about. Do we give people 24 hours? Do we give people 10 days? What is the procedure that actually satisfies the Constitution in a particular case? And the problem is everybody's just making this stuff up as they go along because the Supreme Court basically said, just give people time to do that. So they weren't very clear in what to do. And because they weren't very clear, we are stuck in these situations now where the Fifth Circuit's trying to determine what happens next in terms of what is the proper procedures.
The most important thing is for them to determine how much time someone gets and access to a lawyer.
Correct. From the moment that the government declares someone an alien enemy, how much time does a person have to file a habeas? What access do they need to be given to a lawyer to be able to file a habeas? How long is that deportation order stayed for? Can the person have an appeal? All of that kind of stuff needs to be decided. The government basically wants to give people 24 hours, and the plaintiff side wants at least 10 days to be able to challenge these, which seems reasonable from the standpoint that sometimes people get apprehended. They're in detention. It takes several days to try to figure out where the person even is, much less to then get a lawyer and write the habeas complaint, file it in court. So this definitely becomes a complicated issue.
Right now, let's say you're arrested and they want to deport you. I mean, how much notice do they have to give you if you're a regular deportee?
Well, if you're a regular person that the government is trying to deport, when they detain you, they have to give you what's called a notice to appear. Then that notice to appear puts you in a deportation proceeding, usually the next hearing, which is called a master calendar hearing, which is the equivalent of like an arraignment in criminal court where you plead guilty or not guilty. Here you would plead, deportable or non-deportable, is usually in several days after that if you're detained. And at that point, you would ask the judge, hey, I need time to find a lawyer. And the judge would give you time to find a lawyer. And that could be a couple of weeks, 30 days, etc. And then, you'd have a new hearing. So from that perspective, usually there's much more time given. But what their government is trying to do in these Alien Enemies Act cases is to skip all of that and say that because you're an alien enemy, you don't get any of that process. You can just be apprehended and put on a plane to some country. And so that's the question is if you're trying to skip that whole process, how long do you have to give someone to say, hey, you got the wrong person. Why am I being put on this plane? So that's the question is how long do you have in that scenario?
And also, I've heard other lawyers say that it's sometimes difficult to figure out where your client is being held.
Correct. When people are apprehended, they can be placed anywhere in the United States by ICE. There is a thing online called the detainee locator, but sometimes it takes 2 or 3 days for the person's name to even get uploaded to that detainee locator. So if someone's been detained, you may not know where they are for 2 or 3 days. And then in order to get a lawyer to that detention facility, which is often in a remote location, in order to sign all the paperwork needed to file the lawsuit, ends up being quite onerous. So if you only have 24 hours to file the habeas, how could potentially someone who doesn't even speak English, file a federal court lawsuit within 24 hours? That's the question that the courts are going to have to consider here.
The Fifth Circuit is the most conservative circuit in the country, so I take it that this is the worst circuit to be hearing this from the viewpoint of immigrants?
Well, correct. This wasn't a strategic decision by the plaintiffs. The plaintiffs happened to be detained in Texas, and so the last Supreme Court decision said you have to file the habeas in the location where the person is detained, because in that case, they had the habeas in front of Judge Boasberg in D.C., and Judge Boasberg in D.C. was ruled not to have jurisdiction, so they had to file the habeas in the Southern District of Texas. They were actually successful in the Southern District of Texas to get that judge to say that the Alien Enemies Act required more notice and was unconstitutional. But now the notice issue goes to the Fifth Circuit, and now the Fifth Circuit is going to be in a more conservative posture than that individual district judge. And so the question is what they're going to do there.
Let's turn to a deportation case that is widely known. Kilmar Abrego Garcia, who was wrongly deported to El Salvador and is back in the country, but in jail.
So his lawyers made an unusual request on Friday to keep him in criminal custody until July 16th, when a judge has scheduled a hearing. It's not often that you see a person's lawyer saying, keep him in prison.
Well, I think the concern that Abrego Garcia has is if he is released from criminal custody, then he will be placed in ICE custody, and ICE is saying that they now want to deport him to some other third country, which they have the right to do because Abrego Garcia does have a removal order, but it's a removal order that prevents him from being sent to El Salvador, but not from another country. And so theoretically speaking, Abrego Garcia can be sent to a third country. And so pursuant again to this Supreme Court decision that at the moment says that there doesn't need to be these extra protections for third country removals, that he could be sent anywhere, to any country in the world other than El Salvador. And so he's saying rather than being sent to any such third country, he'd rather remain in U.S. criminal detention to see if he can figure out a way to ultimately come up with some legal strategy that allows him to remain in the United States.
Why would the government rather deport him than try him criminally?
Well, I think the problem is, if he is in criminal court and he's been given a bond, which means he can actually walk around as a free man while this case is pending, that's the nightmare scenario for the government right now. They didn't want any scenario where he was actually walking around in America again. And so their preferred scenario was that he be criminally prosecuted, detained, and then serve his sentence and then removed. But if they can't achieve that scenario, because he will be allowed to actually walk around free for a while this case is pending, then for them, the better scenario is just to deport him and not criminally prosecute him, because they just will not abide by a scenario where he's actually free and walking around.
The Trump administration has agreed to release from prison a 3-time felon who had fired shots into a Texas community. He's been deported 5 times. He was going to be deported a 6th time in exchange for his cooperation in the prosecution of Garcia.
Garcia has never been convicted of a crime. So why release a convicted felon just to get testimony against him?
I mean, at the end of the day, if they don't have any other evidence that links Abrego Garcia to human trafficking, and this is the only person that can link him to human trafficking, then they have to make a strategic decision as to what would incentivize this person to give this testimony. And if this was the only thing that would incentivize this person to give this testimony, then they had to do it. Just like, in mafia cases, you do this kind of thing all the time, where you give people witness protection or other things in order to testify against other co-conspirators. In the immigration world, that this does happen, where people get immigration status in exchange for their testimony. It's just a question of whether here the harms outweigh the benefits, in the sense of whether Abrego Garcia is such a danger to the society that it justifies releasing this other person who is dangerous to the society. So that's the question the government needs to answer. And we'll see. Maybe they don't end up getting around to all of this because they just end up deporting Abrego Garcia now to a third country. So we'll see how that happens. But if they actually have to go through a criminal trial, then they'll have to make this decision about whether this individual is now so important that they can justify keeping them in the country released freely in order to put Abrego Garcia into prison.
Because I assume that the Abrego Garcia case is so well known now across the country that the Trump administration has a lot at stake in actually deporting him or convicting him.
Correct. They do not want him free walking around the United States. And so either whether it'll be by deportation or by criminal prosecution, they want him either detained or deported. And if this is the top scenario, then you will have to do what you can to accomplish that scenario. So that would include potentially giving a star witness the incentive that is needed to be the witness. But obviously that's something that will be able to be impeached in a trial. If there is a trial, they'll be able to say, hey, are you just making all of this up because you're getting this extraordinary immigration benefit? And that's what we're going to have to see.
And Leon, the witness, Jose Ramon Hernandez Reyes, he was going to be deported a 6th time. Do you often see people coming into the country illegally 5, 6 times?
So it depends what the government wants to do, because they have the authority to prosecute someone who's re-entered after being deported and putting them in prison for quite a large amount of time. Or they can just execute the deportation order without such a prosecution. So if they do that, then yes, you can have people deported 3, 4, 5 times, because all they have to do is what's called reinstate the previous deportation order. They don't have to even get a new one. It's literally a form that gets done that allows a reinstatement of the prior order, and the person is just deported again. So every time a deportation order is reinstated, that counts as another order. But what is rare is you don't usually see that within the context of the government continuing to allow it over and over and over and over and over again without charging the person for re-entering as a deported person. At some point they say this has to stop, so they'll put the person in prison, and it could be several years that you could put the person in prison for re-entering as a deported person. And so, why wasn't that done earlier in this process?
Thanks so much, Leon. There's immigration news every day these days. That's Leon Fresco of Holland Knight. Coming up, the California governor sues Fox. This is Bloomberg. California Governor Gavin Newsom is suing Fox News over its coverage of a conversation he had with President Donald Trump about protests in Los Angeles. He accuses the network of deliberately misrepresenting comments to claim that Newsom lied about the phone conversation. Newsom is seeking $787 million in damages, citing a similar defamation lawsuit Fox News settled with Dominion Voting Systems in 2023. Fox News has responded that the lawsuit is a transparent publicity stunt and frivolous, and plans to defend it vigorously and seek its dismissal. Joining me is defamation lawyer Jeff Lewis. Jeff, tell us about the basics of Newsom's complaint against Fox.
Well, the gist of the lawsuit is that Fox News misrepresented a couple of calls between Trump and Newsom preceding the deployment of the National Guard. And Fox News tried to paint a picture that Newsom was lying about not being called by President Trump. That's the gist of the lawsuit, and Newsom is seeking, millions of dollars in damages for defamation per se.
So now he's alleging that this was deliberate on Fox's behalf, that they made deceptive video edits and false statements?
Yeah, and by the way, they have to allege that it was intentional because Newsom is a public figure. He's a political figure. And so under New York Times versus Sullivan, he has the burden of proving not only that Fox News said something false, but they said so with actual malice, meaning they knew what they were doing. They knew what they were saying was false. And so there has to be allegations of intentionality or this case will be dismissed.
Newsom is seeking $787 million, and that number seems to be symbolic because it is about the same amount that Fox News paid to Dominion Voting Systems in 2023 to settle a separate defamation lawsuit over the network's election coverage.
The Fox News lawsuit and settlement with Dominion figures prominently in the storytelling of this complaint. You read the first few paragraphs, and that's part of this piece of trying to demonstrate that Fox News hasn't learned a lesson and is acting intentionally to try to get past the actual malice standard.
And in the Dominion case, discovery revealed some information that Fox would rather have kept hidden. And could that happen again here in discovery?
Absolutely. There will be text messages, communications about this interchange and how, for example, how Fox News vetted this story and did anything to verify what President Trump was saying on his social media about the timing of these calls. So there will be discovery, and the discovery can prove to be embarrassing.
Are there hurdles here with questions about news and commentary and whether you're, shading the truth or just making a comment on a political figure?
Yeah, that's a great question because in this case, he has tried to essentially allege the tort of false light, which is related to defamation. And false light is taking facts, taking clips, and editing them suspiciously to place you in a negative light to suggest you're either lying or that you aren't telling the truth. That's the gist of what Governor Newsom has alleged here. And so in a traditional defamation case, you're looking for a false statement of fact, something that's provably false. And here it's more about, through deceptive editing, whether or not Newsom was shown by Fox News to not know what he's talking about or be inaccurate in terms of his recollection of phone calls with President Trump.
It does seem like there is evidence. There was just a 16-minute phone call between Newsom and Trump, and that it took place either late on June 6th, California time, or early on June 7th on the...
Yeah, but let me just say this. Truth is a defense in defamation law, And you don't have to be exactly right on all the details. There's plenty of cases out there that say being substantially true or close enough is good enough in the world of defamation. And so I don't know if the gap or the inaccuracy of saying it was a day ago as opposed to 3 days ago will be enough to convince a court to let this escape a motion to dismiss. It's kind of a weak defamation claim, if you ask me.
The Chiron did read Gavin lied about Trump's call.
Yeah, well, and what Fox News showed was a Truth Social post by President Trump with the call log showing that there was a phone call. And the question is, will that be enough? Will that be close enough to the truth to allow the lawsuit to be dismissed? Or will Newsom be able to say, well, this casts me in a false light, makes me look like I don't know what I'm talking about?
And tell us about the cause of action under California's unfair competition law.
That's not going anywhere. Let me tell you, this is a law that is usually used to protect consumers against false advertising and claims like that. And it's not going anywhere because under California law, you're not entitled to damages. You're entitled to restitution. So if Governor Newsom could somehow prove that Fox News made $1 or $2 or $10 off of this story, could tie it directly to that story, the best Governor Newsom could hope for is to get restitution of those profits. But that's not going to be proven here. That claim is going to be dismissed.
Apparently, the lawyers offered to drop the lawsuit if Fox retracts the comments and apologizes. Is that a good deal for Fox?
It is a good deal if all you care about is paying money in terms of legal fees for defense. It's a bad deal in terms of Fox News might enjoy the exposure. Fox News might enjoy being the antagonist to Governor Newsom. So there are non-monetary issues here.
This is sort of echoing or copying Trump's strategy of suing the media. I mean, he has that suit alleging that CBS Network edited an interview with Kamala Harris to favor her. And that's got to be a difficult case to prove.
Yeah, again, because of the issues involving a public figure having to prove actual malice, and it's more of a false light as opposed to a provably false fact. And those are all hard things to prove in a defamation claim, because defamation claims are really hard to win. Prior
to Trump, have there been a lot of political figures that, sued for defamation over unfavorable coverage?
Well, in California, you see a lot of lawsuits against political opponents, things that are said during the heat of campaigns. But usually those lawsuits are directed at your political opponent, not the media, not the person holding the microphone.
How do those suits end up? Because I can imagine almost every politician could sue the opposition.
That's right. Well, in California, we have a very robust anti-SLAPP law, which allows defendants to quickly file a motion to get these kinds of lawsuits dismissed. And they're quickly vetted and either disposed of or settled. They rarely go to trial. One interesting note here, California has one of the most powerful pro-defendant anti-SLAPP laws in the nation. Governor Newsom sued in Delaware, perhaps to avoid application of that anti-SLAPP law and to avoid an early testing of the evidence in this case.
Is this an uphill battle for him to survive a motion to dismiss?
It is an uphill battle, both in terms of the actual malice standard, the issue of whether or not there's a provably false fact, where's the lie, and whether or not he could prove any damages. Now, he's alleged something called defamation per se. And if you go on the air and you accuse someone of being a thief or a murderer, that's defamation per se. You don't have to prove damages. The lie here that was alleged was some confusion over a phone call. I don't know that meets the legal definition of defamation per se. So that means Governor Newsom has to prove some sort of damages flowing from this statement.
He claims that Fox harmed his reputation and may even cost him votes in the future. One wonders how many Fox viewers would actually be voting for Newsom in any event.
Yeah, in the law, there's this requirement called proximate cause. You got to draw a line between the harmful act and actual damages. And in defamation per se, you don't have to draw that line. But in this case, I think he'd be hard-pressed to show any person who actually saw this broadcast would not have already had an opinion previously about Governor Newsom, and that opinion somehow changed. And by the way, Governor Newsom's termed out, hasn't announced that he's running for president, so I'm not sure what vote he's talking about.
I think we know which vote. And hours after filing the lawsuit, Newsom highlighted it in an email to supporters that sought donations to his political action committee. Thanks so much, Jeff. That's defamation attorney Jeff Lewis. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.